officer and temporary judge administrator. Prior to this, he was briefly a research attorney for the court, and for the preceding 16 years was a civil litigator focusing on consumer class actions, real estate and construction litigation, and appeals. He received his JD from the University of Southern California and his bachelor's degree from the University of California at Davis. Andrew Adams is currently the court operations manager of the civil / probate clerk's office. In his role, he provides day-to-day leadership functions for 22 clerical positions, including the probate examiners. He helps to support 3 probate departments and 6 civil departments. Andrew began his career with the courts in 2007, and he's worked in multiple departments, including criminal, juvenile, appeals, civil, and probate. Andrew has a certificate for court leadership from the California Court Association. He's also been involved in the statewide Court Clerk Training Institute, where he designed the appeals procedures training class and was previously taught the civil procedure class for 2 years. So without further ado, I bring to you Matt and Andrew and our program on the e-filing system.
Good afternoon, everyone. Matt Malone, Chief Counsel for the court. I'm going to start us out just sort of with a general overview of where we are with the program. A lot of the details and the good suggestions are going to come from Andrew later. But we did a few of the questions that were submitted had to do with, you know, how has the conversion been received by staff and by attorneys? Are there bugs? Are there issues? Any kind of rollout like this that is this significant and this big a change is going to have a number of issues, and no matter how much training you do on the front end to try to offset that, no matter how many trials you run before going live, you're not going to discover all of the hiccups until the time you're out and about and the program is live. So while there have been issues, I think overall the reception has been very good. That is not to say, of course, that there haven't been the occasional errors, the occasional wrong rejections, things like that I know from the questions people have experienced. But everyone, just so you know, everyone is sort of learning this a little bit at the same time. We at the court had some more time developing it, but again, as we're doing the filings, as we're going through the process, we are learning and correcting throughout. We are in the process of making sure, there was a question about staff and whether we think we have a sufficient staff to handle what's, that the e-filing, and the answer is, yes, we're getting there. It's going to be a matter not only of a number of staff, but of also making sure everyone is trained at specific levels to handle that. That's ongoing. And I think as we continue to use the system, both on the user end and on the court end, things are going to flow a lot smoother. And I do view this as a cooperative process. We need to know from members of the bar and from people who are doing the filing where the issues arise, and that's what helps us to correct them when they do. So we appreciate the opportunity to come here and to talk about it, to address questions, and kind of talk about strategies, which Andrew will, for easing the e-filing process. Because this is an MCLE, I technically do have to bore you with some law, so I'm going to get that out of the way on the front end. It does address some of the questions that I received about, why are we doing e-filing at all? Isn't it unfair that pro-pers don't have to go through the process, but represented folks have to pay to do it? Also, why can't we just send PDFs, email PDFs to the clerks, etc.? Also, some questions about signatures and retention of originals came through. So I'm not gonna share screen or go through statutes with you. I want to reference them for you, and you all can look at them on your own time. The governing statute for this process is Code of Civil Procedure 1010.6, subsection B. This is what allows for an e-filing program. This is the statute that also provides that an e-file document is treated as an original. To that question about original documents, but it and a rule of court also have provisions about declarations made under penalty of perjury. And depending upon how you file documents under penalty of perjury, you may be required to retain originals. So I would encourage you to review 1010.6 subdivision B for that. The mandatory e-filing program is also governed by Rule 2.253 of the Rules of Court. That generally sets up the ability to have a mandatory e-filing program in civil cases. There's not much to say about it other than it's there, and it gives the general parameters of what a program should look like. The last thing I will talk about is Rule 2.257, which piggybacks on the Code of Civil Procedure about the issue of sending documents under signature. The difference is required in e-filing when you're sending something that isn't under penalty of perjury and when it is, and whether you have an electronic signature program or you don't. And if you don't, that's when the retention of an original that needs to be produced upon demand comes up. So I would encourage you to primarily look at 1010.6 of the Code of Civil Procedure, 2.253 and 2.257 of the Rules of Court. And that will be the end of the sort of legal portion of this. We will touch upon some other rules as we go on. The one thing I'll also address is, there was a question about sending PDFs to the clerks and why we use these e-filing programs that cost money. Primarily, what they provide is security. The e-filing programs and the e-filing providers that have to sign on to them go through security checks to make sure that there is protection of the electronic data through the transmission process. That is not available in PDFs to clerks, and also having the clerk staff deal with PDFs. Andrew can talk more about this because he's on the ground with it. Transmitting those PDFs, making sure they're together without the use of an e-filing system would pretty much cripple the clerk's office in terms of its ability to do other work, I would think. But it would be really hard to do that. In addition, the e-filing program provides that service, and that's why it is used here. And I think we're now at, Andrew, correct me if I'm wrong, but we're over 30 courts that have some sort of 30 courts that have one system. Yeah. And so that's why it's being used. I think that from the perspective of cost, because this was another question, why are we having to pay for this? Pro-pers don't. I mean, it's not necessarily equal protection because anybody can be a pro-per, but I think that as we ease into the system, what you'll find is the e-filing fees replace more expensive filing methods that are often used. When I was in private practice, and there was something with a time deadline, I think the only thing I ever regularly filed by mail was a CMC statement, and everything else was sent sometimes by courier. Sometimes we had staff that would bring it down. Sometimes we would overnight it, and the fees are actually less than that most often. So when we get to have more facility with the program as practitioners and here at the court, I think it'll be both more easy and more cost effective. And that is the end of my legal and general overview portion. So Andrew, I'm going to turn it over to you.
Okay. Well, everyone here, my name is Andrew Adams. I am the court operations manager for the Civil and Probate Office. Many of you have probably met and spoken to, any of you I haven't. Nice to meet you all. One of the things I really wanted to focus on today is speed and accuracy. You guys doing your piece, more detail oriented, helps our piece. Because one of the things that people don't really realize is as you submit things, depending on how they're titled, how the document's titled, we have to go in there and we have to edit that stuff. And it's not just you submit it, we hit the accept button, because if we do that, then we get judges who are upset because documents aren't titled correctly. It also ties into appeals, where an appeal tries to create a record and they can't because they don't know what PDF 8653 means. So those are things that you guys just don't know from your end. I'm going to give you a short presentation on PowerPoint. I want you guys to see what the clerk's office is seeing. So when we're talking about like filing descriptions and documents descriptions, what that really means and how it can actually speed up your guys' filings getting filed and our processing of all the documents to make sure they're timely for court. And I know this stuff is important. I know the like estates and stuff like that this time of year, people are trying to sell houses. So we're trying to get all this stuff done quickly and as efficiently as we can. So hoping showing you our side of it can kind of help you guys on your side of it, and then it helps everyone all together. So let me see if I can start this. All right. Can everyone see the screen? Matt, can you see it? Okay, good. So e-filing update, right? So today's 4/12. Just want to talk about, so mandatory e-filing was originally implemented back on 7/5/2022 for local rule 2.87. There are exemptions, as Matt talked about, for self-represented litigants, and any party can move the court for an exemption for that local rule. We are on our 4th amended standing order when it comes to e-filing. As Matt said, we are a work in progress, and as we find things that need to be updated and changed, we will modify that order accordingly. Same thing with when it comes to e-filing. There are things in there that as we do it more, we're realizing things are missing or have been overlooked. So it's just a work in progress. One of the big things people asked is what things are exempt from e-filing, and in the local rules, it talks about that. There's also a FAQ that's on the court's website that talks about that. I just want to give a quick example. Things like ex parte motions / oppositions and letters, all those things cannot be e-filed. Other examples, bonds, subpoenas, all that stuff, citations that need to be issued have to come to the court to be issued. There is a complete list so you can see it. The one thing I'll talk about that is a little bit different from that is when you get orders after hearing, well, they're not technically part of the e-filing order, just by ease of practice and how quickly you need things done, those can be brought directly to the clerk's office for filing. So that's something we kind of had to do right at the very beginning, because you're going to have your letters with you, you're going to have your bonds, you're going to have your order, and we'll do all that at the same time. We're not going to make you go home, e-file an order, bring back the letters and the bonds. That doesn't make any sense for anyone. So, I mean, we're aware of stuff like that. So we try and work with you. Same with, like, you have your ex parte that's exempt from the filing, but you have a declaration that's with it. We're going to file all that stuff at the same time. So, I mean, we're trying to make it as easy as possible to use while still following the rules. Okay. Let's see. So some of the tips for speeding up e-filing, one of the really big things that's important for us is we do a daily triage of the previous day's filings every single morning. I have clerks who are assigned to that, and specifically they're looking for things that are coming up within the next 2 weeks, because we want to make sure that those tentative ruling issues are being addressed, because it doesn't help you, it doesn't help us, creates more work to have those hearing dates continued just because we did not get to them yet. Okay. So one of the main things is in document description, and I'll show you exactly what I mean by that in a little bit, is if you put in when your next hearing is, it's unbelievably helpful if you do that. It quickly lets me go through a list of 200 documents and go, okay, I know these 15 are coming up on calendar in 3 days and I have to get them filed, right? Same thing with, like, your document description should be matching your document title. Those are two things the court has to retype pretty constantly. A lot of you guys are doing it correctly. And it's wonderful. It makes it really, really quickly. It makes us process quickly, I should say. The other thing I run into a lot is this picking the security level of your documents. One of the biggest things I notice is when we get guardianship cases, every single document is picked or is marked as a confidential document. And we know that's not true. So the clerks have to take extra time to go back into it and recategorize the actual security level. So that's just another piece that takes us a little bit more time. Ensuring your documents are legible. I mean, sometimes I get some scans that are a bit questionable. If they're questionable and I can still zoom in and read them, I will take them. It's very rare that we will reject one for being illegible, but it is something we need. So ensure your scans and your PDFs are clean and legible and not cattywampus off to the side. Make sure all the pages are facing the right way. Those are some of the things I see regularly. One of the other comments and questions I got is, how do we contact or how do we communicate with the clerk's office regarding hearing dates? There is a comments to court box when you're e-filing that comes over to the clerk's office. And I'll let you know, we do read those. We absolutely read those. I mean, I'm sure there's going to be 1 or 2 times here or there where we're going fast and we miss it and we set it on a date you don't like. Call us. We can fix that. One of the great things about e-filing is your submissions, while we accept the documents, or let's say we even have to reject the documents, is we have a record of what you've submitted for at least 60 days. So if there's a question as to what was requested or did the clerk miss something, we can always go back and see it. And if it's something on the clerk's end, I have no problem with my office fixing it. It's not a big deal. Whether it's resetting a hearing because you're not available and we miss that, I don't have a problem with that. Okay. The other things you can put in there is if there are timeline restrictions, like if there's a probate code or some code that says it has to be heard within a certain amount of days, let us know. And then it turns into a logistical issue for us. So I have to work with the examiners, I have to work with the judges, figure out when we can set these things that do require special time circumstances, because it does happen and it's going to happen. So anything you can put in that comment box is really helpful. The one thing I have seen too is that the request for the next hearing, this piece up here, you guys end up putting it actually in the comments to the court. So that's something we can't see when we're doing triage. And I'm going to show you that in the next slide here, an example. This is exactly a screenshot of what the clerk's office sees on a daily basis. You're going to see we're going to have envelope numbers over here. Envelope numbers is like your purchase order number from the actual e-filing vendor. Now, we ask for that all the times when you call because it's really helpful for us to specify which envelope you're talking about if you have multiple submissions. Worst comes to worst and you don't know it, just give us the case number. I can also search for your cases in your filings by your case number. So if you can get the envelope number, it's great. If you can't, don't sweat it. Just give us the case number. We can find it. All these other things in here are different things we're looking at. We get submission date, we get the status, and I'm sure people have questions about the status. So status submitted just means that we received it and a clerk hasn't actually gone there and looked at it. Under review means we've opened the envelope and closed it. Whether we're opening it just to see if it's coming up on calendar really quickly, or if we're opening it to processing. Anytime we open it and close it and don't finish it out, you're going to have under review. Same thing, you can see the very top one right here. This is where we've actually opened an envelope, accepted 2 of the documents for filing, and then we close it. This is a little practice we have to do because it allows Odyssey to build the case for us. So then we can actually give you court dates on your like petitions or probate instead of having to get that awful TBD and we have to send you a notice. So that's our way of getting around that. So we can actually give you court dates immediately. The next thing I'm talking about is the filing code. The filing code should be uniform across all e-filing providers. It's specific to initial filings have their own set. Subsequent filings also have their own set. This is all something that we built through Tyler. We had to send them a very, very long list of what we wanted and what we didn't want. Our main idea was to keep it simple. We really didn't want to have 8 million things in there and then it just gets confusing for everyone. There's a lot in there currently, and there's a lot more we will most likely have to add. Just the other day, I realized one of our things like petition for special immigrant juvenile findings was not available in initial filings. That's something we had to reach out to Tyler and have them update. And I want to say 1 or 2 things every week I find that we need to update. So it definitely is a work in progress, like Matt said, and we appreciate your patience. One of the things I'd say, if you're questioning a filing code, there's always miscellaneous filing. If you do miscellaneous filing and you still describe it correctly as the title of your document and your document title, then we can the clerk's office can update any filing code and make it the appropriate one. It's some easy fix we can do. So don't stress about that piece too much. The next part with the little red thing, that is the most important part to me. Filing descriptions. That's where you can get really specific. And your filing description should be next hearing, whatever your hearing date is, and then the title of your document. That's really, really helpful. It really lets us go through this really quickly. Even down here, like when I took this, there were 203 subsequent envelopes to go through. And that is just for probate. That is just probate subsequent. My office is not just in charge of probate subsequent and initial. We also have civil. And between the 2 of them, I sit around 4,000 to 4,200 envelopes to go through. So anything we can do to make it faster for the clerk's office, we're going to ask you guys to do because we want to get your filings done. And I mean, we have to focus on probate, but I also have civil. So I've asked the civil attorneys to do this as well. And it's very helpful. Here's an example. This filing right here came in and the filing description had that hearing date on it. So when I was reviewing this on 4/6, I can quickly go, oh my goodness, this is coming up in a week. This is most likely addressing some issue that the probate examiners have pointed out. And some of the things I'm looking for, even if you don't have like the hearing information right there, which is helpful, but I'm looking for reports of counsel. I'm looking for declarations that are going to address tentative rulings. I'm looking for proposed orders that are going to be coming up on calendar in the next day or 2. Oppositions to petitions, replies to things, anything that a research attorney or a judge is going to need for an upcoming hearing, those are priorities for us. Not to say that we're not going to address everything else, but we definitely do that triage every day to try and get those things done so your hearings don't get continued. Now, I'll tell you, probate in general is about a week behind. And that's going to fluctuate. It's always going to fluctuate depending on the amount of filings we receive and the number of staff we have. I mean, we would always love to get lower, but I can't guarantee anything like that. But I would like to be able to guarantee that I can get hearings, documents for hearings that are coming up filed timely. Okay. So let's see what one of the things about that, one of the questions was about proposed orders. Proposed orders we can receive in the system, and that's totally fine. And it lets the examiners know that it's there. And it's one of the things they check off on their list. If you're looking to get a copy of your order back, please submit a proposed order directly to the examiner's office with an envelope. Once it gets signed, you can even include your letters with it. Once it gets signed, it's either going to sit in the department waiting to be picked up, or you can request that the department send them downstairs to the clerk's office for filing. I have clerks who are assigned to each department to take care of their orders, and they do them within, I want to say, 3 to 5 days, if not sooner. They have to pick them up every single morning and work on processing them throughout the day. Okay. All right. This is a little bit of the description I want to talk to you guys about. So up here, this is your filing code. That's your first thing. So that's what you're actually picking. So if it's a declaration, call it a declaration. If it's a waiver, call it a waiver, right? And that's just the base part. The really important piece is the filing description. That piece should be matching what the title of your document is. It is incredibly time saving. When I come in here, I look at it, the document, the filing description is the same as the title. And then same with down here, it's the document description is the same as the filing description. Those are what the clerks are having to update. We don't update those things, and the judge doesn't know specifically which this declaration is addressing. And same with when we go to build an appeal record, it makes it incredibly difficult to build that appeal record when we get multiple declarations on the same day and it just says declaration of. So those are very, very important. Same with like messages to the clerk we talked about earlier right here. You put I'm unavailable for a hearing July 1st to July 15th. We will do our best to avoid those dates. Sometimes what will happen in there is you guys will request dates and they're just full. At that point, if they're full, we can't give you that court date. The other thing you can do with that is if you talk to Eric or Dana or one of the examiners, and they have basically given you a pre-approved date, let us know in this filing comment what that pre-approved date is. You tell us in here, we're going to double check with them. And we even have a system where every time they give you guys a pre-approved date, they send a message to me, my leads, and my probate filing clerks. So they know about it. So they'll specifically look at that and go, okay, I know this is reserved for that date, and we'll overset things. Very, very helpful. Okay. So the other questions were kind of about common issues / rejections. The clerk's office has the authority to change a lot of things like filing codes. That's easy. We can update document descriptions. One of the things we can't change is your payment type. We specifically cannot go in there and change it to a fee waiver. So many times, if you have a case, say a guardianship that has a fee waiver and you're submitting another petition, I can't waive those fees unless I reject it back to you and go, please select waiver. And there's a whole specific like setup, like process for creating a waiver account. And you can actually find that on Odyssey's landing page about questions and issues. Some of the other ones we have is when we get consolidated cases, we still get submissions into the subordinate cases. It will not take them. We're trying to accept them. What ends up happening is your filings will actually error out and go into a whole separate queue that our IT department actually has to monitor, or Tyler monitors. And at that point, we're going to have to send it back to you and say, please submit into the lead case. Okay. Some of the other things, we get large exhibits that are broken up, submitted without cover sheets. I mean, I know that there's restrictions on the size of documents that are allowed to be submitted through e-filing. I believe it's 25 megabits. And I've had people ask, who set that? That's not a function that's determined by the court. That's actually determined by the Tyler people. So that I don't know if that's to protect the system for it being too large or slowing the system down too much, but if you do have to break up your exhibits, please include cover pages. So example, like declaration regarding whatever, part 1, and then the next one, part 2, and give us somewhere to actually file stamp them, okay? Some of the other ones, amended filings are submitted, but not identified as amended. No, that happens. please make sure that your documents say amended. Because if we see it and we're going to be checking it against the system, we see it looks exactly the same. It's going to be a quick rejection for us going, hey, what is this? It's not amended, it's a duplicate, please let us know. One of the other ones I get all the time is subsequent pleadings that are submitted as a new filing. When you have an open case, if you don't submit it into an existing filing, it will try and open it up as a brand new complaint, which then it's going to want to charge you the 435 or whatever applicable filing fee. And then that's how we end up with duplicate cases regarding the same issues. And we really, really don't want to do that. I do give out refunds for this because this definitely is a learning curve, but just be aware of that. If you have questions specific for what you can and can't like e-file, like technical issues, I included a link from Odyssey that is a really good like search function that you can search in questions and it'll pull up lots of answers. It's very helpful. My clerks use it when we questions from parties asking specific e-filing questions. And we found out many answers that way. I would encourage you guys to use that. The other one I didn't talk about was documents are illegible. I think I kind of covered that when I was saying make sure that your scans are good quality. So that's important. So some of the other things that I kind of want to bring up. One of the questions I got was e-filing ribbons versus file stamps and why we use the e-filing ribbon versus an old-fashioned file stamp. For my office, it comes down to efficiency. As I stated, I don't just have probate, I also have civil, and I have over 4,000 envelopes to get to. And every envelope can have one document, it can have 30. Anything that can speed that up, that's what I'm looking for. I want to be able to process your documents timely. It's very important to me. And that's why we use the ribbon. The ability to go into an envelope and you've titled your document correctly, and the document title, the description is correct, and the document title is correct. My file stamp's already on there, and I just have to go accept. That takes me 10 seconds versus having to rename documents, having to move around a file stamp. That is why we do that here in civil and probate. There will be times where the document is, let's say there's a DocuSign thing at the top and I know it's going to get covered. We'll remove the ribbon at that point. And then from there, we'll actually put on the regular file stamp you do see sometimes. My only issue with the regular file stamp is it's actually built of 5 different stamps and can get broken quite easily. And that's why we don't use it very often, because it can be quite tedious sometimes. Some things I've seen some of the offices doing is they've been moving their pleadings down and leaving extra room at the top. And that seems to have alleviated that problem a lot. I know a lot of you guys aren't used to the ribbon. I know federal court uses it. I know LA uses it. It's definitely a time-saving measure for us. Very, very helpful. Let's see. Some of the other things that I wanted to bring up, the probate examiners asked me to talk about this. Please, when you're doing ex partes, please make sure you come back and actually pick up your documents. They have a lot sitting up there, or provide them envelopes. If you provide them envelopes, they can bring them down to the clerk's office for filing. That's one of their big things. So those are some of my main issues we kind of come across in e-filing. I hope seeing the clerk side of it will really help you guys understand what we're looking at and how to help speed up our processing so you guys can get your documents back further. I'm happy to give this PowerPoint out and you guys can look at it, give it to your staff, your people, so you know exactly what we're looking at. I have no problems with that. But other than that, those are the main things I really wanted to share with you guys today and some of the issues and problems we've been running into. So. Do we have any other questions?
Okay, let me look here and see what's going on in the chat. First question is, are there any updates on a standard procedure for returned orders and getting letters issued?
I would say to that, Joe, that was kind of like when I was talking about with the probate examiners, get them a copy of your order with an envelope to be returned. Include with that your letters, because what they can do is and tell the judge at the hearing that, hey, I don't need my order, just send it downstairs to the clerk's office for filing. They can take those documents because they keep a tickler and they go over and they talk to each judge every morning and they bring those orders with them. So as long as the examiners already have your order with an envelope and your letters, we should be able to get everything back to you.
This is actually an interesting question. Is there a preferred placement for an exhibit stamp, top of the document versus bottom, or a standalone divider page from your end?
That's a good question. I would say at the bottom. If you're going to be putting an exhibit stamp or something or a label on it, I'd put it at the bottom. And that's totally fine. Make sure your cover page still has exactly what the document is, and there's a spot for us to put another file stamp on it if you're breaking up exhibits.
Okay. Another question here is, would you suggest that we contact the court to see if a case number has been assigned prior to filing any documents, any subsequent documents, I think is the question. There might be a typo in there.
You definitely could. The other thing you could also do is you could go to the court's public portal, search the name there. One of the features that I tell people all the time is when you're looking for someone's name, if you type in the last name and then you put an asterisk next to it, it's something called a wildcard search. So it searches everything regarding that person's name, anything close to it. So if you're not finding anything and you want to double check, you can always call the courthouse between 10 and 2. My clerks are happy to try and look up a case for you.
That's interesting. So you literally can when you're searching on the system, you type the name with an asterisk instead of.
Yeah. So I would do Adams, asterisk, and then Andrew, and it's going to pull up every Andrew Adams case there is.
That is good to know. I'm glad that question came through. Next one. If the tentative ruling is requesting a declaration by the petition to submit an original account statements in a conservatorship matter, can that be filed in person? So the original documents are provided, or should that be e-filed instead?
It should still be e-filed. Once we get them e-filed, they're still considered originals. We accept them the same way. And then especially if they're in the tentative ruling, like that thing I talked about putting in your next hearing date in your description, that next morning when I get it, I'm going to automatically process it because I know it's within 2 weeks.
I think you already addressed this one a few minutes ago, but someone commented that sharing a copy of the PowerPoint would be very much appreciated. So, sorry, this is a long question. Okay, when initiating a new trust case in e-filing, we're required to enter the name of the trust, but the format provided is a first name, last name box. Is there any way to change this to simply one box that is trust name? It currently makes you enter in both the first and last name boxes.
Yes, there should be a business type. You should be able to change it from name to business. And when you make it a business type, then you can type the Andrew Adams Trust 2005 all in one big long line.
Actually, and this is a question that I personally would like to. Could you repeat for us what you said regarding ex partes, particularly probate ex partes? And we did get a lot of questions that specifically hit ex partes. I think that's a good subject to, lawyers love to repeat things over and over and over again. So
Sure.
Give it to them.
Yeah, so currently ex partes are not subject to the e-filing order. So those still have to be brought in person. Even talking to Dana and Erica, let's just say hypothetically, if they came in ex parte, came in by e-filing, there's no mechanism to let them know it's been filed. So bringing it directly to them or they hold it that day and make sure there's no oppositions is the most efficient way, as we see right now, to deal with those probate ex partes.
Okay. I'm not. Question is, will probate be able to see and download filed documents? Maybe they're asking about the probate examiners. I'm not sure I understand the question.
I think they're talking about documents online. Matt, do you want to talk about that?
Well, sure. We also got a question about whether they're going to be available for public viewing. That's actually governed by a rule of court. For public remote access is Rule 2.503. There are some probate documents that could be online. Some case types, it's not allowed at all. Guardianship and conservatorship, for example, or our DVROs are not permitted to be publicly remote accessed. So and Andrew, I don't know if you know better than this. I don't know about the status for the other types of documents, if they're viewable now or if that's in process. But probate has several types of cases that could be public and several that are not remotely accessible at all.
Currently, nothing probate is available online.
When e-filing a proof of service, is it preferable to e-file the proof of service page as the first page of the document?
So I feel like this is kind of regarding notice of hearings. Does that make sense?
It would in the probate
Yeah.
context, yes.
No, I would still keep that the actual proof page as page 2 and still file your notice of hearing, like where you have the notice on top, what's actually the petition it's regarding, and then your service is attached to page 2 and 3.
And then I guess the flip of it would, if we're not talking about a notice of hearing and they have a proof of service, of a non-judicial counsel form or of just of another pleading, more akin to a civil pleading. Would you suggest that be the first page, or?
I would always suggest there's a cover page. Have it be a cover page, titled correctly, correct, proper legal format, and then have your actual proof of service on page 2.
Okay. San Francisco County has filed orders online after the hearing that we can click on to open. Monterey County returns orders through the electronic filing system back to the filing attorney. Are either of these options being considered to get orders back here? I'm paraphrasing a little bit there.
Yeah, currently, I don't believe we have that ability to do that. So, I mean, that's also something Matt and I can kind of look into a little bit more. We're always interested in what other courts are doing, just to see if they're specifically something we can do, especially if they're Tyler courts, and it's just something we're not aware of, or it's an add-on program that we don't know about and can look into getting. But, Matt and I can look into that issue. I know the orders after hearing is a big deal for people. I really do. So trying to figure that out, anything we do to try to figure it out, we will.
Broad question, but is there any way to avoid getting a notice of wrong e-filings and avoid a last minute cancellation of hearing?
Interesting question.
Yeah.
So generally, as long as you guys start using that next hearing date thing that I showed you in the slide, there shouldn't be any last minute cancellations of hearings as long as we're getting everything that's required from a tentative ruling. So hopefully that will resolve that issue. I'm sure there's going to be things that it's just not identified correctly as something we would triage that might require a continuance. One thing I talked to Judge George recently about this, she's like, anything that you're submitting within 42 hours, send them a courtesy copy. Well, not 42, 48 hours, send her a courtesy copy so they know it's coming. And if you want to include there something showing that you've submitted it through e-filing so the judge knows that it's pending, you can do that. The examiners look at that too and they know it's pending, that's great.
I would add to that, I'm speculating a little bit because I'm not sure if this local rule still exists, but I know it did exist prior to Judge George, back when she was serving as commissioner, in between Commissioner Green and Judge Sugiyama, that there was a local rule that you shouldn't submit anything closer than 48 hours to a hearing. The court has the discretion to not consider it. The court, in my experience, doesn't exercise that discretion very often, but knowing that it exists, I think that an answer is to try to avoid filing things within 48 hours of a hearing whenever you can. That goes kind of above and beyond the e-filing part of it, but I thought I'd throw my preachy 2 cents in there. Anyway, how do we register attorneys to get documents e-served on them? Also, if we e-serve an attorney, do we have to file a proof of electronic service?
So when you're doing e-filing, there's a spot where you can add in email addresses that you want to get e-served copies of whatever pleading you're filing. Matt, tell me if I'm wrong, but I'm pretty sure that that does not, it's not bar you from the requirement of actually still having to serve them.
Don't believe so.
Someone would like you to repeat again what you said about DocuSign
Sure.
in particular.
So I've noticed we get a lot of documents that are DocuSigned, and generally DocuSign documents, you know they are, because at the very top of the page, there's a little thing that has DocuSigned on blah, blah date. So when I get those, obviously our filing ribbon is going to fight with that. So what we do on those type of cases is we will actually, as long as we don't think there's going to be room for the ribbon, we will remove it and add the manual electronic file stamp. So just because we want it to be clear, so you still can see the ribbon very clearly. It's something I care about a lot to make sure that ribbon is clear and visible. So we are watching for that.
Fantastic. Will the examiners hold checks for issuing letters if we're sending them the proposed orders, letters, etc.? Self-addressed stamp envelope. If they're sending it that way, I guess, yeah.
If you send it all to them, they're going to keep it all just clipped together. I mean, I'll double check with Erica and Dana, but as long as it's all together, I don't think they're going to be taking it apart. They're going to leave it. It's going to go to the courtroom. We'll probably put it in the envelope so it doesn't, the check doesn't go missing, and then they can submit it downstairs.
When filing a new probate, do you send a blank notice of hearing with the petition? Does the clerk give the date on the notice?
That is a great question, something I forgot to bring up. No, we do not. So that notice of hearing, so just so you all understand, when it comes to stamps on electronic filings, the only time we can add a stamp and it's going to stick is if we're filing it. So those blank notice of hearings that you send us that we keep sending back to you and saying, please don't submit until service, there's no way for us to put the hearing date on there without having a file document that's not complete in our system. And that's why we send it back to you going, hey, please don't submit this to us until it's actually been served. So in most cases, you're going to get that issue. So don't submit the blank notice of hearing. I know that was something that was a practice we did for years and years and years, but there's no way for me to do that without accepting it. And we're not going to be accepting documents that are incomplete.
Fantastic. This question, the person asking the question has experienced a quote system slowdown at times when submitting docs, and then asks whether the slowdown could be vendor specific or something on the court's end. That's kind of a common thread with some of the questions we've got. Could you answer that question, and then beyond that, can you give us some examples of some of the issues that have popped up that are more of a vendor issue versus an e-filing system or court issue?
So Joe, I've never heard it be vendor specific. I have heard it be a e-filing issue in general. One of the times I noticed it in my office is near the end of the day when we've processed a whole bunch of filings, it can slow down on us. And what we actually get is emails from Tyler saying there's going to be intermittent disruptions or slowdowns. And it's not just our court that's affected. It's all courts that use Tyler e-filing. And so I know that email goes out to all vendors. All vendors get that email. Whether they share it with you guys, I don't know. Yeah, I can't think of a time that it's specific. Like it's always like 10:30 in the morning. The only time I get it pretty consistent is near like 5 o'clock.
Okay.
Yeah.
And then are there any other issues that you think are particularly relevant to point out to everybody that would be under the category of vendor issues and not necessarily I'm not making excuses for you. I'm not saying, hey, it's not your fault, but if it's not your fault, I think that would be good to share with everyone, because it helps a lot of times. We have a hard time putting ourselves in someone else's shoes and seeing it from their point of view.
I haven't noticed anything vendor specific for probate. It's been very, very easy. I have to say it's probably been the smoothest out of between civil and probate. Just for example, civil has over 42 case types, and that's not 42 times basically 3, because we have multiple limited types, we have unlimited types. And getting things to process correctly it's more converted data than new things. But probate, I haven't ran into any of those really specific issues. I think I have a list of about 15 cases court-wide that have odd developer issues with Tyler that we can't e-file into, and we can't figure out why. I think one of them is probate. That's it. Otherwise, things seem to be going rather smoothly for the submission process, at least from our end.
Okay. Here's a good one. Since you can e-file any time of the day, any day of the week, is it more difficult to get filing processed on a Monday, for instance?
That's a very good, from the e-filer side, I don't know the answer. I mean, I would assume if there's less traffic coming in, it's going to be quicker. I know I've heard this from people. There is a delay sometimes between when you submit to your vendor, between when they submit to us. That's going to be vendor specific, and I would advise you to talk to your specific vendor at that point.
Yeah, this is purely anecdotal. In my experience, the probate legal world seems to be its busiest between 7 a.m. and noon on every Monday. So follow that logic wherever it takes you, I guess. So question for Matt. Would you repeat the rule that regulates electronic signatures for probate filings that you had mentioned in the beginning of the webinar?
Yeah, sure. You're looking at Code of Civil Procedure 1010.6, subdivision B, and it's specifically B2, I believe. And then Rule 2.257 of the Rules of Court. And that it essentially, it's very similar, but the statute asks the Judicial Council to make rules, so there's a little bit of difference there. So I would review both of those for electronic signatures. The real question for those kinds of signatures is, and whether you have to retain an original, is whether you're talking about something that is submitted under penalty of perjury, a declaration, something like that, and then whether or not you are using essentially a DocuSign or some other kind of electronic signature. That electronic signature, that term is defined in Rule 2.257. So to be something like DocuSign that is unique to you and attached and can be identified as yours. In that case, the rule doesn't require the retention of an original, but if in any other method, that original for something submitted under penalty of perjury has to be retained, and there's demand procedures, I believe both in the code section, again, 1010.6 subdivision B, and in Rule 2.257 that require you being able to produce it upon demand.
How does the court rectify incorrectly rejected documents if they were filed by the deadline? So how do we resubmit it so that it's considered to have been filed on its originally filed date? Is it a note to the clerk or?
So this is a good point. This does happen from time to time. Someone calls, I look into the issue, and if we can deem that it really is an incorrect filing, you just put a note. Who you spoke to, per Andrew, this should be backdated to whatever date, and we can look at the original submission date, and it's something that's really easy for us to do. And what we just changed the docket date and we backdated to the original submission date. That's the really great thing about e-filing, that it keeps all the submissions, not just the accepted, but also the rejected. So I can see exactly what date and what time and what the document was, and it's really easy to kind of do that review. And if something was kicked incorrectly, we can correct it rather quickly.
And this is I think this touches on something you said earlier, but I think it's a little broader, which is the court considering or moving toward having all documents available for online viewing and or printing?
And the short answer to that is yes, where permitted. It's not, again, certain case types cannot cannot be, again, we have to be careful what we're talking about. Public remote access, where it's just a member of the public coming in and remotely and looking. There's a lot of prohibited case types. Where possible, I think the sort of ideal is to get as much available online as possible to minimize the need for coming in for copies or things like that. There are limitations, though, again, in the rules of court, so it won't be something that's going to be available for every case type.
Gotcha. And similar, is the court moving towards a future where we scan retroactively, where we're historically going back in time in case files?
So we are working that way. We are starting with civil. We figured that was going to be the easiest case step to kind of learn. We are sending them out to a big scanning company that's working on it. So it is taking time. We do have to teach that company how to index things properly and make sure they're doing it correctly. So it's difficult sending these things to a company that aren't court clerks, because unless you're a court clerk and attorney, you don't know what you're looking at. So training those people to be able to do that has been helpful. We've also actually taken one of our court operations managers and moved her specifically to destruction and scanning. So her full-time job is working on that. So, I mean, it's a work in progress, but it's definitely something we're envisioning happening and working and striving towards.
Oh, this is an interesting question here. If there's a statute of limitations issue, is that something that to include in the document description itself, given the possible delay in processing at times? The concern would be having a filing rejected after the statute of limitations has passed.
I would suggest putting that statute of limitation issue in the filing comments to the clerks. If you have something that's really time sensitive, or there's a statute issue running, give me a call. I don't mind looking up that case and looking at it, seeing what we need to do if it needs to be rejected. It happens quite often in civil cases where we have personal injury cases that are hitting their final deadline. And they'll call. I'll look up the case. I'll make sure there's no issues with it and it's not going to be rejected for any reason. Doesn't necessarily mean it gets processed right then because there are the people in front of you, but at least I can give you that reassurance that your document is fine for the clerk's office to file and it will be filed before that statute date runs.
Now that documents are being scanned in, everything's being e-filed, do we still need to indicate by fax on documents that are not originals, given that all documents are now being scanned into the system?
Matt, what do you think?
I'm not sure. I guess I don't understand the question. Indicate by fax.
So they're not really being filed by fax at that point, right?
Yeah.
So I don't think you would need to.
No, I don't think so. That's what the question is.
Okay. So I think the answer is if you'd put by fax only if it's being filed by fax, and the e-filing system is self-evident that you're filing it via e-filing at this point. Okay. I don't see any new questions coming in. Let me look at all of the questions really quickly that were submitted prior. Just so the audience knows, we submitted all of the questions that were pre-submitted, so a lot of them were dealt with in the actual PowerPoint presentation preemptively.
Andrew, the only one I didn't check off was we talked about was the case. Maybe we did talk about this. Is a case number always required to submit a document, and how would an attorney of the court identify a new case for filing? If that
Talked about it a little bit.
Okay.
Joe asked about it a little bit, but yeah, generally, if you're filing an existing case, a subsequent filing, you need a case number. If it's a brand new case, you're going to file it as a brand new case.
And that's an indicator. They don't have to.
Yes. Yeah, you have two options. Yeah, into an existing case or new case.
Yeah.
Couple of one also, and I believe we discussed this prior to the presentation. You guys obviously cannot, as the court, suggest vendors or providers, one versus the other. And so I just wanted to reiterate that, make that clear to everybody that I'm not ignoring those questions. It's just that the court's not allowed to to make those suggestions. But it's definitely something like anything else to ask around, shop around, find out what other people are recommending, because there seems to be a bit of variance from vendor to vendor. I thought I'd take that one for you. If you want to add anything, go ahead. If not, you can just leave it there.
I'll say one thing, Joe. I've done some research on this before too, because it came up with another issue. And from the 4 or 5, I ended up looking into just easily. It seemed dependent on the number of filings you submitted. So if you're submitting over 100 versus over 500, it gets cheaper the more documents you submit per month. That's what I noticed. And so also depending on what type of payment you're using, I noticed there was a variance there, whether you're using credit card or e-check. So things to keep in mind.
And I have one, again, you hit on some of this, but we're almost at the time. We've made it through the required 1 p.m. at least. And I don't see any new questions coming in now, but you go over just in general, again, what are some of the more common causes of having a filing rejected? Just kind of the greatest hits, if you will.
Okay, yeah. Some of the main ones is you're submitting a subsequent document as a brand new document. Same thing is, I think I talked about this 2 or 3 times, is when you have large documents and you're splitting them up. You're not putting cover pages on it. You don't give the clerk's office another place to stamp the second piece of it. So like if you split an exhibit right down the middle, we're not going to be able to file stamp part 2 if there's no cover page on part 2. The other one I see a lot too is, instead of submitting each document as its own PDF, there's 4 or 5 documents all as one large PDF, and I don't have a way of splitting those up for you. So making sure that you submit each document as its own PDF is legible. Those are kind of the main ones I see a lot of the times. And just about anything else we can fix on our end, but those are ones we can't fix.
Okay. Well, I think that is it. I don't see any new questions coming in, and I've exhausted all of mine. So thank you guys both. Maybe one of the powers that be will beam in here. Oh yes, Matt.
I think maybe we'll do this. We'll send around the PowerPoint, and we'll send it through the Bar Association for distribution. And then I think we'll include I don't know if they have contact information for us, but we can include it there as well once that gets with that email. So people have if they have further questions, I'm more than happy to answer them.
Fantastic. Thanks, guys. This was very informative. Much appreciated.
Thank you, everyone.
Thank you,
There
guys.
was, I'm sorry if I missed this. There was one person raising their hand. Do you want to take one more question real fast?
Sure.
Joel, if you still had a question, go ahead.
Yes. I had submitted with a petition for letters of administration a nomination of the proposed administrator, and the e-filing changed it to nomination of a guardian, and when I challenged that, they said, well, we had limited numbers of categorization, and that was the closest we could pick, which was obviously not correct, but I didn't know what else to do with that.
I mean, that sounds pretty close. I mean, there is a basic consent type of filing. So, I mean, if it's a consent of a guardian or consent of a nomination, you could call it that. If you can't find anything else, just call it miscellaneous filing, and that's close enough. I mean, the title of the document is just that. It's a title of the document. As long as we actually have it for review by the judge and the examiner, that's the most important piece to me.
Thank you, Andrew. There's 2 more people raising their hands. You want to keep going?
Sure, we've got some
We got 10
time.
minutes. Yeah.
Okay, Carolyn, go ahead.
Looks like she's muted.
Or Sarah, you can go ahead.
They both appear to be muted.
Yeah, I can't. Let's see. Ask to unmute. Carolyn or Sarah, did you have a question? Okay, they retracted their hand. So Okay, thank you so much, Joe, Andrew, and Matt, and everyone. Thank you for joining us today. You will get the PowerPoint when you get your attendance certificate, so that'll still be about 7 days out, okay? But you will get that, and thank you all so much.
Thank you, everyone.
Thank you, everyone.
Bye.
Bye.